5 seconds to go. Start. In criminal jurisprudence, while the offense is against the society, it is the unfortunate victim who is the actual sufferer, and therefore it is imperative for the state and the prosecution to ensure that no stone is left unturned. It is also the equal, if not more, duty and responsibility of the court to be alive and alert in the course of trial of a criminal case and ensure that the evidence recorded in accordance with law reflect upon every bit of vital information placed before it. It can also be said that in that process, the court should be conscious of its responsibility, and at times when the prosecution either deliberately or inadvertently omit to bring forth a notable piece of evidence or a conspicuous statement of any witness with a view to either support or prejudice the case of any party, should not hesitate to interject and prompt the prosecution side to clarify the position or act on its own and get the record of proceedings straight. Neither the prosecution nor the court should remain a silent spectator in such situations. Like in the present case, where there is a wrong statement made by a witness contrary to his own record, and the prosecution failed to note the situation at that moment or later when it was brought to light, and whereafter also the prosecution remained silent, the court should have acted promptly and taken necessary steps to rectify the situation appropriately. The whole scheme of the Code of Criminal Procedure envisages foolproof system in dealing with a crime alleged against the accused, and thereby ensure that the guilty does not escape and the innocent is not punished. It is with the above background we feel that the present issue involved in the case on hand should be dealt with. The court noted that while it is true that Section 301 places limitations on the right of the private person to participate in criminal proceedings, nonetheless, Section 311 empowers the trial court to summon witnesses in order to arrive at a just decision. The court held in that context, therefore, a reading of sections 301 and 311 together, keeping in mind a situation like the one on hand, it will have to be stated that the trial court should have examined whether invocation of section 311 was required to arrive at a just decision. In other words, even if in the consideration of the trial court invocation of section 312 was not permissible, the anomalous evidence deposed by PW 18 having been brought to its knowledge should have examined the scope for invoking section 311 and set right the position. Unfortunately, as stated earlier, the trial court was in a great hurry in rejecting the appellant's application without actually relying on the wide powers conferred on it under section 311 CRPC for recalling PW 18 and ensuring in what other manner the grievance expressed by the victim of a serious crime could be remedied. In this context, a reference to some of the decisions relied upon by the counsel for the appellant can be usefully made. Stop.